All right, so AP US Government and Politics Review Part 6, again, made by Steve Miller from Walter Johnson High School. He can always contact me if he doesn't like me using his PowerPoints. Civil liberties and civil rights are going to be about 10% of the test. The development of civil liberties and civil rights by judicial interpretation and knowledge of substantive rights and liberties are the issues. So the politics of civil liberties, the objectives of the framers, they wanted to limit federal power. The Constitution was a list of do's, not don'ts, but the Bill of Rights is specifically about what the government cannot do. It was not intended to affect the states, at least until the 14th Amendment. And the 14th Amendment was only interpreted to mean that it affected the states starting in the 20th century, and the process of incorporating the Bill of Rights, First Amendment, Second Amendment, and so on, of protections to the states, well, not necessarily Second Amendment, began in the 20th century. The Bill of Rights is essentially a limitation on popular rule. It says the government cannot do this even if the majority would like it to be able to. So even though a majority of Americans would like to pass a law that says you cannot burn a flag in protest of the United States, that violates the First Amendment. And so therefore the majority does not get its will. Okay, politics, culture, civil liberties. Liberties become a major issue for three reasons. Rights are sometimes in conflict. Sometimes there are competing rights within the Bill of Rights. So in the Shepard case, that was about a doctor who was accused of murdering his wife. Free press rights versus fair trial rights were involved because the press was reporting things in such a way as to make anybody who read their reports be fairly convinced that he was guilty. And so he was concerned that he wasn't getting a fair trial because the jury might have been improperly influenced. New York Times and Pentagon Papers. Issues of national security versus free press rights, freedom of the press. Kuhn's anti-Jewish speeches, free speech versus public order. Policy entrepreneurs are most successful during crises, especially war, by arousing people. So that's a really kind of clunky way to put this. Let's look at some of the what are they getting at? They're getting at individuals who've been able to essentially limit your, for the most part, your freedom of association or your freedom of speech. Those individuals have been most successful during a crisis. So, for example, it was easier to get the Sedition Act of 1789 passed because the French Revolution was going on. It was easier to have the Espionage and Sedition Acts passed in World War I because of the war. The Smith Acts of World War II. The Internal Security Act of 1950 during the Korean War. The Communist Control Act of 1954 during the McCarthy era. So when we're afraid of a group, a dangerous political group, it's easier for them to pass laws that restrict people's ability to associate or people's ability to speak out in support of that group. Cultural conflicts. The United States was originally settled by white European Protestants and African slaves. Waves of immigration brought new cultures and conflicts. Non-Christians, for example, are offended by government-sponsored crosses at Christmas. English speakers prefer monolingual schools. There can be differences even within cultural traditions. So lots of things. I mean, here's a classic conflict. The Confederate flag. For some people, it's a symbol of their Southern heritage. For other people, it's a symbol of racism. Interpreting and applying the First Amendment. Speech and national security. By 1917 through 1919, Congress had defined limits of expression. So basically treason, insurrection, forcible resistance were things you couldn't advocate. This was upheld in the Schenck case, which argued that if speech produces a clear and present danger to the nation or to the people, then it can be limited. 14th Amendment due process rights had not been applied to the states originally, but the Supreme Court moves toward more freedom of expression after World War I. However, communists are convicted under the Smith Act under the gravity of evil. By 1957, they've created a new test of calculated to incite. By 1969, the Brandenburg case, speech is only limited if it would create an imminent unlawful act. In other words, very quickly, almost immediately, there will be some sort of illegal activity as a result of the speech. In 1977, a march by Nazis in Skokie, Illinois, which had a large Jewish population, was upheld as constitutionally protected free speech. Hate speech, for example, is permissible, but not hate crime. So what is speech? 4 kinds of speech are not fully protected. Libel, written statements defaming another person by false statements. Public figures have to also prove malice. They have to prove that someone's really out to get them and destroy them. In the case of a regular person, you just have to prove that the statements are false and that they harmed you in some way to prove libel. Obscenity. The 1973 definition of obscenity is something that is patently offensive by community standards of an average person. And so you have this kind of, what would a community standard look like? What would the typical person view as obscene, offensive? And they go into the description of basically if it depicts sexual activity in a patently offensive manner. That's Miller versus California. Zoning ordinances upheld. So free speech zones. You can require people to not stand in a certain place to protest. This was one of the things that's been controversial since at least Bush 43. I remember when the second Bush was president, that he had a tendency to create zones where people could protest against him, but they were kind of far away from where he was at. And Obama has done a little bit of that too. Regulation of internet. The CDA bill held unconstitutional because it restricted adult access to indecent material in the course of attempting to restrict the access of minors. So the CDA was a bill designed to protect children from horrible, nasty things, obscene things on the net, but it went too far according to the courts. So that was Reno versus the ACLU. Symbolic speech is another type of speech. Acts that convey a political message without actually talking. Flag burning, draft card burning. It is not generally protected if they would be otherwise illegal. The exception is flag burning. So this restriction of symbolic free speech is protected. Texas versus Johnson. So this is the way to put it. The draft card is not private property. It's actually government property. So burning the draft card, you can get in trouble for because you're destroying government property. That's the premise on that. Flag burning. I suppose if it's illegal to burn something in a certain place, then it's illegal to burn the flag. But if you can get a burn permit, you can burn a flag. Yeah, go ahead.
A burn permit?
Yeah, you can get a permit to burn stuff. Yeah. I don't know if you should be able to have a permit to set fire to anything on a street, though. That's kind of odd. But they've upheld flag burning, so I don't know all the particulars on that. Seems a little strange to me. Testing restrictions on expression, how things work. The Supreme Court has employed various standards and tests to decide whether a restriction on freedom of expression is constitutionally permissible. A preferred position. The right of free expression, though not absolute, occupies a higher and more preferred position than many other constitutional rights, such as property rights. This is still a controversial rule. Nonetheless, the court always approaches the restriction on expression skeptically. So your First Amendment rights have a preferred position. Prior restraint. With very few exceptions, the court will not tolerate a priori restraint or prior restraint on expression, such as censorship, even when it will allow subsequent punishment of improper expressions, such as libel. So we tend not to prevent someone from being able to libel someone. We just then they are responsible for the damages. Imminent danger. Punishment for uttering inflammatory sentiments will be allowed only if there is an imminent danger that the utterance will incite an unlawful act. So, and this goes beyond simple fighting words. This is a charged situation with two groups that really don't like each other, and someone says something that causes someone else to feel threatened somewhat, and then it leads to a riot. Something like that. Neutrality. Any restriction on speech, such as a requirement that parades or demonstrations not disrupt other people in the exercise of their rights, must be neutral. That is, it must not favor one group more than another. So if you're going to allow parades for Thanksgiving, you have to allow gay rights parades too. That kind of thing. Clarity. If you must obtain a permit to hold a parade, the law must set forth clear as well as neutral standards to guide administrators in issuing the permit. Similarly, a law punishing obscenity must contain a clear definition of obscenity. Least restrictive means. If it is necessary to restrict the exercise of one right to protect the exercise of another, the restriction should employ the least restrictive means to achieve its end. For example, if press coverage threatens a person's right to a fair trial, the judge may only do what is minimally necessary to that end, such as transferring the case to another town rather than issuing a gag order. So who is a person? This is where it gets interesting. Corporations usually have the same rights as individuals, although there are more restrictions on commercial speech. However, recent court decisions have treated corporations more and more like real people, which hurts my head, but that's what the Supreme Court has decided. Regulation, more restrictions on commercial speech. Regulation on commercial speech must be narrowly tailored and serve the public interest, but advertisements have some constitutional protections. But you can see that there are limits on commercial speech. For example, you can't have cigarette ads on TV. Young people may have fewer rights. In the Hazelwood versus Kohlmeyer case, school newspapers can be restricted because the principal essentially has editorial rights over the newspaper. And this is the case even if the newspaper is self-funded. As long as the newspaper is produced in school, as in written and produced in school by a club or by a class, then the principal has editorial privileges. Wouldn't stop students from forming their own newspaper outside of school, though. Wouldn't have any effect on that. And this went down in 1988. I was a student, and I was in journalism in 1988, and things were pretty interesting. And then after this decision, all of a sudden, our editorial page was a lot more boring. Church and state. The free exercise of religion clause, no state interference, similar to speech. Law may not impose special burdens on religion, but there are no religious exemptions for laws binding everyone. So, for example, use of illegal drugs in religious ceremonies. You don't get to do those. Some cases are difficult to settle. Conscious objectors to war and military service. The refusal to work on Saturdays. Unemployment compensation as a result. Things like that. Wisconsin versus Yoder was a Supreme Court decision that had to deal with one of these special issues and decided that Amish children can be pulled out of school after 8th grade. The Establishment Clause, Jefferson view, wall of separation. Jefferson views church and state as being separated by this Establishment Clause wall. Congress at the time argued that it was no national religion. The Supreme Court has interpreted it much like Jefferson did, which is a wall of separation, which is truly interesting because Jefferson was not one of the framers of the Constitution. They struck down school prayer, creationism, in-school release time. That would mean you're released out of school to go do religious activities off school grounds. Benediction at graduation and prayer at football games. The reason behind this is that their argument is that essentially this is creating a privileged place for a certain religion, or it becomes coercive. If you're having school-led prayer, then it creates pressure on people who would not otherwise pray to pray just to get along with other people, and creates dynamics where someone might get picked on, for example, for not praying. And it would be a mistake to pretend that wouldn't happen. That would happen. But it also has allowed some kinds of aid, government aid, to parochial or religious schools. There's a 3-part test, the Lemon Test, for constitutional aid. It has to be for a secular purpose, a non-religious purpose. It has to neither advance nor inhibit religion, and it should not get government entangled too much into the religious institution. Okay, so some issues with the Establishment Clause. What do you do with nativity scenes at a government building, say City Hall? And what they've ruled is you can't have one religious scene, say for Christmas, the winter holidays. If you have just Christian symbols, that's not constitutional. But if you mix it up with reindeer and with Jewish symbols and things like that, it's okay. Crime and due process, the exclusionary rule. Most nations punish police misconduct apart from the criminal trial. The United States punishes it by excluding improperly obtained evidence. The Supreme Court ruled in Mapp versus Ohio, 1961, the exclusionary rule, the idea that any evidence gained illegally cannot be used in court. So the exclusionary rule, there are a couple of exceptions. I don't know if they're going to be on the next slide, so I'm going to talk about them right now. There is the inevitable discovery exception. The evidence was going to be found anyway, so we're going to go ahead and get to use it. And that's hard. They actually really have to prove that they were going to find that evidence before they can use it. And then the good faith rule. So if a police officer or another officer of the court is performing what they consider to be a legal activity and they find evidence, under the good faith rule, there's a very good chance that they can go ahead and use the evidence. For example, if they have processed a search warrant and the address is off a little bit, but the police officer actually takes it to the right address, even though the number's off and everything, that the good faith rule may allow for an exception there where the evidence would still be allowed even though there was a technical error. Speaking of search and seizure, when can reasonable searches of individuals be made? Well, you have to have a properly obtained search warrant with probable cause, and it's incident to an arrest. What can police search incident to an arrest? The individual being arrested. So if you're arresting somebody, then you can search the individual being arrested, things that are in plain view, things under the immediate control of the individual. And what about an arrest while driving? It changes a lot. The courts have attempted to protect a reasonable expectation of privacy, but it's pretty easy for a police officer to keep you on the side of the road for a while if you don't want them to search your car. They can bring a drug dog out to sniff around, things like that. Most people probably let a police officer search their vehicle just to be able to go home. I probably wouldn't, because I'm stubborn. Testing for drugs and AIDS. Mandatory AIDS testing has not taken place. Government drug testing, I don't even know what he's talking about right there. Government drug testing is now in the courts, but private testing is okay. Supreme Court, some testing is permissible. Law enforcement and railroad employees, for example, can be forced to take drug tests. You can have random sobriety checks on drivers. But the key is to be able to do these tests. It has to be for a concern for public safety or national security. If you are a high school student participating in extracurricular activities, including athletics, you can be required, in order to participate in that stuff, to take a drug test. And the way they usually do it is with random drug testing, because it's expensive to have everybody take a drug test. I know to become a school teacher, I had to take a drug test and pass it. So did all the other teachers, if you were wondering. Confessions and self-incrimination. There's the constitutional ban originally against torture, extension of rights in the 1960s, the Miranda case, Miranda rules to prove voluntary confession. Okay, so in the 60s they came up with the Miranda rules specifically to prevent someone from basically being coerced and forced into a confession. And even with the Miranda rules, a lot of people still kind of get coerced into a confession anyway. One of the concerns we always have is people who are not of high intelligence, low intelligence people who get stuck in there with police officers can be, they can talk them to death and then talk them into confessing. It's happened before. Relaxing the exclusionary rule. Okay, so they're going to bring up good faith exceptions, but I've already talked about that. So move on. Okay, so civil rights. Civil rights issues are issues where a group is denied access to facilities, opportunities, or services available to other groups, usually for ethnic or racial reasons. The issue is whether a difference in treatment between one group or another is reasonable. Some differences are things like progressive taxes that are considered reasonable. So the amount you pay on your taxes can change based on how much you make. However, I think that's kind of not even the greatest example because everybody gets taxed the same way. It's just if you make $30,000, this is how much you're going to pay. If you make $50,000, that extra $20,000 you make more than the person who makes $30,000 may be taxed differently. But if that person who made $30,000 made $20,000 more, they'd have the same tax rate as the other person who made $20,000 more. So I don't know. That's and that goes into how progressive taxes work in brackets. And I hope you guys understand that the way taxation is supposed to work is that there are brackets, and when the percentage that you pay on your taxes changes, it only changes for that extra amount you make in the next bracket. So in a simplistic way, let's pretend this is the rate. The first $20,000 you make, you pay 10% income tax on. This is not real numbers, but let's pretend that. Then if you make an extra $10,000, you pay 12% on the money you make from $20,001 to $30,000. And for the money you make past $30,000 up to $50,000, you pay 14% on that money. So, you don't, if you make more money, you don't pay more taxes on the lower tax brackets that you of income you already had. That's something people don't seem to understand. You're never going to lose money, at least on the rate, on the percentile rate, by making more money. You might lose out on exemptions, but that's a different thing. All right, some differences are not reasonable. Classification by race is usually not reasonable. It's subject to something called strict scrutiny. When someone wants to make a difference between black and white, then they have to make an incredibly, amazingly compelling argument, and it is assumed that the policy is wrong until they somehow find some way to prove it right. That's what strict scrutiny basically means. So testing restrictions on expression. Now we're getting into some civil liberty stuff and civil rights stuff. Let's see here. The Supreme Court has employed various standards and tests to decide whether a restriction on freedom of expression is constitutionally permissible. This is really more civil liberties than civil rights. It's kind of weird. But preferred position, the right of free expression, though not absolute, occupies a higher, more preferred position than many other constitutional rights, such as property rights. This is still a controversial issue. Nonetheless, the court always approaches a restriction on expression skeptically. Prior restraint. With scarcely any exceptions, the court will not tolerate a prior restraint on expression, such as censorship, even when it will allow subsequent punishment of improper expression, such as libel. Imminent danger. Punishment for uttering inflammatory sentiments will be allowed only if there is an intimate danger that the utterances will incite an unlawful act. Neutrality. Any restriction on speech, such as a requirement that parades or demonstrations not disrupt other people in the exercise of their rights, must be neutral. That is, it must not favor one group or another. So if you allow an Irish St. Patrick's Day parade, you have to allow the Nazis to do their parade too. Clarity. If you must obtain a permit to hold a parade, the law must be very clear and neutral Similarly, a law punishing obscenity must contain a clear definition of obscenity. Least restrictive means. If it is necessary to restrict the exercise of a right to protect the exercise of another, the restriction should employ the least restrictive means to achieve its end. For example, if press coverage threatens a person's right to a fair trial, the judge may only do what is minimally necessary to that end, such as transferring the case to another town rather than issuing a gag order. So now we get into African American civil rights. All right, so in the textbook you guys in third period use, but fifth period doesn't use, the term majoritarian politics is used. And I'll just kind of explain what that means. Majoritarian politics means politics driven by majority interests, but majority interests worked against African Americans. What changed? Well, lynching shocked white people, but little was done about it, partly because they were still images and it was viewed as an aberration, something that didn't happen on a regular basis. General public opinion was opposed to African American civil rights. And those sympathetic to granting African Americans more civil rights weren't clear on how to get there. What did progress on civil rights depend on? More whites changing their mind about segregation and discrimination, and shifting where civil rights actions were taking place. So how did the civil rights movement succeed? By publicizing the problems with discrimination and segregation and moving their struggle from Congress and trying to get legislators to pass laws to protect civil rights and going to the courts and suing and getting the courts to do things. So, and this goes back to that idea of in our system we have multiple points of access. If you want to get things changed, you can go to your congressperson, you can go to the executive branch, which could be at the state level, the governor, it could be the president at the federal level, and then if nothing else works, you can always go to court. So, the ambiguities in the 14th Amendment. A broad interpretation of the 14th Amendment would argue that the Constitution was supposed to be colorblind. A narrow interpretation would be that they just simply put legal rights were equal. And what does that mean? Well, the Supreme Court adopted a very narrow view of equal legal rights in the Plessy case and argued that separate but equal was acceptable. Although there was one Supreme Court justice who criticized the decision of the majority and said that, come on, everybody knows better. You know better. That's not what's going to happen. The NAACP set out to involve courts in desegregating schools, which were obviously separate but not equal. And so that's one of the ways they attack separate but equal. You go somewhere where it's really obvious that there is inequality in the system, which was the public school. So Brown versus Board was a class action lawsuit. The decision held that separate schools were inherently unequal. So segregated schools were inherently unequal. But resistance to enforcement of Brown versus Board did not end until the 1970s. Still, schools today are very segregated, but it has to do with the neighborhoods people live in, not because of the law. And in the 70s, there was an attempt to address that issue through busing. And busing still continued past that in some places. But busing's pretty controversial because nobody likes to have their little kid wake up at 5 o'clock in the morning to go to school and go across town instead of just go to the school down 2-3 blocks from the house. A court case, Swan versus Charlotte Mecklenburg, 1971. Dealt with proof of intent to discriminate and argued that a school where there is predominantly one race creates a presumption of intent to discriminate. And they came up with remedies including quotas and busing and redrawing school district lines. Although they did say every school was not required to reflect the racial composition of the school system. So there was some flexibility. It's not like they were going to say, well, if 40% of your students in your school district are African American and 45% are white, and 15% are everybody else. Not every school has to be literally 40%, 45%, and 15%. 1992 decision allows busing to end if segregation caused by shifting housing patterns. So they've not pushed busing as hard. So if there's de facto segregation going on because of changing housing patterns, they're not going to continue busing. All right, so the Civil Rights Campaign in Congress. Mobilization opinion by dramatic events to get on the agenda was the order of the day. So how do you do that? Through set-ins, freedom rides. Remember, we watched the Freedom Riders. They on the buses, not the guys writing stuff, but the guys literally on the buses, getting beat up. The Birmingham riots. Martin Luther King making speeches, demonstrating, protesting. The Senate Judiciary Committee was controlled by Southern Democrats who opposed integration, but 3 developments broke the deadlock. Public opinion changed because of violent reactions of segregationists, and the fact that the media focused in on that, and the fact that television was able to show it literally happening. And people sitting at home, watching television, watching someone get hit with a club, or have a dog attack them, or a fire hose on them, that caused a lot of people to realize that that discrimination and segregation was much more harmful and unfair and damaging than they had previously thought. Kennedy's assassination, 1964 Democratic landslide. Democrats won big in 1964. So 5 bills were passed between 1957 and 1968. Voting rights laws, 1957, 1960, 1965. But 1965 is the one that's really effective. And in 1968, a housing discrimination law was passed. For a long time, it was very easy for someone to not rent to someone that they didn't like because of their race, or not sell their home. The 1964 Civil Rights Bill is extremely important, and it dealt with employment and public accommodations, and it was justified constitutionally by Congress's power to regulate interstate commerce. Basically, they argued that discrimination against African Americans or other racial groups led to commercial interference and problems. If you're an African American businessman and you go from one state to the next and you go to a hotel and they won't accommodate you, they won't let you stay there because of your ethnicity or your race, then it hurts your ability to do business. It's a really broad interpretation of the Commerce Clause. But the 2 big ones here for the test would be the Voting Rights Act of 1965 and the Civil Rights Act of 1964. And then that 1968 housing discrimination law. Okay? So, voting rights 65, civil rights 64, 68 housing discrimination. Women and equal rights. Supreme Court's position altered after the 1970s, somewhere between reasonableness and strict scrutiny standard. It's gender-based differences are prohibited by the courts. You have to kind of show a reason, and it's got to be a compelling reason. But some things they've decided have to be the same: age of adulthood, drinking age. Jobs have to be very careful with their height and weight requirements. Pregnancy leaves, Little League exclusions, JC's exclusion, unequal retirement benefits. Some of this stuff I don't think is going to show up on a test. But yes, unequal retirement benefits. You basically have to, in theory, treat men and women the same in the workplace. Although women often don't have, the equal pay movement talks about how women jobs, how shall I put this? Jobs where women predominate and the skill set that's required for that job, and jobs where men tend to have the job and have the same skill set, the jobs that men have that have the same skill set tend to pay better. They're not the same job, but they have the same kind of skill set. And so some people argue that we need to do something about that. And we need to mandate some sort of equal pay rule. It would be very difficult to make that work, though. Gender-based differences allowed by courts. You can have all-boy, all-girl schools. There's a property tax exemption that widows get in some states that's been allowed, that they don't give a corresponding tax exemption to widowers. Delayed promotions in the Navy. That example I'm not up on. Statutory rape. The states can have differences as far as their laws concerning statutory rape. I'm not exactly happy with that, but that's apparently what they've decided. Women must be admitted to all male state-supported military colleges. Is a decision that was made in the last 20 years. Rosker versus Goldberg. It's okay to draft only men. That's a 1981 court decision. Now we get to sexual harassment. There are two forms: requesting sexual favors as condition for employment. So if you want to keep your job or you want to get a job, you have to do something nasty. The other type of sexual harassment is hostile or intimidating work environment. If you work in a work environment where your coworkers are making comments and behaving in a way that you feel is hostile or intimidating, you can act on it. However, there aren't a whole lot of federal laws governing this, although it's constitutional for states to have fairly strict sexual harassment laws. And the way it's pretty much done is businesses have a responsibility to make sure there is not a hostile or intimidating work environment. It's not enough for them to be able to say they didn't know it was happening. It is the responsibility of the business to know what's going on and to know what kind of environment the workers are working in. Abortion. Until 1973, abortion was regulated by states only. In 1973, Roe versus Wade happens. It struck down a Texas ban on abortion. A woman's freedom to choose was protected by the 14th Amendment right to privacy that was first described in Griswold versus Connecticut in 1965. Griswold versus Connecticut was a case where a married couple were fighting the state of Connecticut over their right to use contraceptives. So what was the decision in Roe versus Wade? That states could not pass regulations against abortion in the first trimester. That in the second trimester, the only ban that could be allowed had to make exceptions to protect a person's health. And in the third trimester, basically kind of the same thing, just a little more leeway on the part of the states. People who don't like the Roe versus Wade decision argue that life begins at conception, and they argue that the fetus is entitled to equal protection. Supporters say that no one can say when life begins. The Hyde Amendment in 1976 in a law required that no federal funds be spent on abortion. And under Bush, a gag order on abortion referrals was imposed. It was removed under Clinton, reinstated under Bush 43. So Republican and Democratic presidencies tend to have different positions on the abortion issue. 1973 to 1989, the Supreme Court withstood attacks on Roe versus Wade. In 1989, the court upheld a Missouri law that restricted abortion in ways that previously they hadn't allowed. The Casey decision lets Roe stand but permits more restrictions: a 24-hour wait time, a requirement that parents consent to a minor's abortion, pamphlets that have to be handed out, things like that. What we've seen over time is states are being given more freedom to basically make it more difficult for a woman to have an abortion, make it more unpleasant. And lately what we've seen is states create health laws that make it more difficult for an abortion clinic to exist. And the number of abortion clinics have diminished over time in some states. Affirmative action arguments. The equality of results used as a measure for need. So now we're on to affirmative action. Racism and sexism can only be overcome, according to people who favor affirmative action, by taking them into account in designing remedies. They argue that equal rights is not enough. People need benefits to overcome historical racism and discrimination, and argue that affirmative action should be used in hiring. In other words, an active attempt to increase the number of people from groups that have been historically discriminated into various jobs and into colleges and so forth. So the issue becomes equality of opportunity. What does equality of opportunity mean? Reverse discrimination is a kind of poorly worded concept to describe discrimination against the majority. It's also used to deal with the idea of allowing minorities to have preferential treatment, or to allow women to have preferential treatment. And people who don't like affirmative action argue that laws should be colorblind and sex neutral, and that the government should only eliminate barriers, not actively try to fix the problem. So it's a pretty controversial issue, because people who see the legacy of discrimination argue that that's not enough, that just being colorblind and sex neutral isn't enough, because the way things have worked, white males kind of have a lead in the race, so to speak. And there needs to be some sort of adjustment, accommodation made. But then the trick becomes, what accommodations do you make? And how far do you go? So targets or quotas. This issue has been fought out in the courts. There's no real clear direction in Supreme Court decisions. The court is deeply divided, affected by conservative Reagan appointees to the court system. Law is complicated, confusing. The Regents versus Backey case pointed out that an absolute numerical minority quota is not permissible, but you can use race as a factor in admissions. In emerging standards for quotas and preference systems, there has to be a compelling justification, and it must be used to correct a pattern of discrimination. Things they can do. For example, entry into undergraduate universities. How can you do that without creating some sort of slant? One way to kind of create affirmative action is, we all know we still have disadvantaged schools. We all know we still have situations where we have poor schools, where the population is largely made up of minorities. And what do you do for the kids there to give them an opportunity to go to university? One simple solution that seems to get around the quota issue and seems to be kind of fair is to use class rank. If you go to a great school and you're first in your class, and you don't go to a great school and you're first in your class, you're still first in your class. You've made the most of the opportunities available to you. And so the argument is that's one way to kind of create a more level and fair playing field, to create opportunities for people who come from poverty, or come from a family that has been affected by historical discrimination, to have a chance. And I'm bringing it up because I like that one. I like the idea of class rank having being a way to get into college. Congressional efforts to defend affirmative action have not yet been successful. Compensatory action, helping minorities catch up versus preferential treatment, giving minorities preference, applying quotas. These are issues. It's just complicated. Public supports the idea of compensatory action, but they do not support the idea of preferential treatment. But the argument comes down to, what is a compensatory action and what is preferential treatment? And one person's compensatory action can look a lot like somebody else's idea of what preferential treatment is. So it's very difficult. And we'll move on. Homosexuals in the Supreme Court. The Barwood case states that may ban gay activity. The right of privacy does not cover. Georgia law actually covered all sodomy, not just homosexual. However, Lawrence versus Texas case in 2004, the Supreme Court held that private, consensual homosexual activity cannot be banned by the government. So this is within your lifetime. Big changes have happened in the issue of gay rights and same-sex rights, things like that. Colorado case prohibits law that would deny homosexuals the equal protection of the law. State law passed by referendum would have prohibited counties and cities from guaranteeing equal rights for gays, but it was struck down. Boy Scouts case. Boy Scouts of America are a private association, not a public accommodation, and they may therefore discriminate against homosexuals. And that goes to your freedom of association. You get to join the groups you want to get to join and define what that group is. And I know that sounds weird because it's saying you get to keep people out, but that's the whole point. Is some of the groups you join are based off of a certain value system you might hold, and if the government forces you to let people join who don't share that opinion, you don't really have a group, right? So here we go. Key provisions of major civil rights law. 1957, voting made it federal crime to try to prevent a person from voting in a federal election. Created the Civil Rights Commission to look into civil rights problems in voting. 1960, authorized the Attorney General to appoint federal referees to gather evidence and make findings about allegations African Americans were deprived of their right to vote. Made it a federal crime to use interstate commerce to threaten or carry out a bombing. 1964, voting made it more difficult to use devices such as literacy tests to bar African Americans from voting. Barred discrimination on grounds of race, color, religion, or national origin in restaurants, hotels, lunch counters, gasoline. So we're getting a Civil Rights Act 1964 here. Movie theaters, etc. Schools authorized the Attorney General to bring suit to force the desegregation of public schools on behalf of citizens. Employment outlawed discrimination in hiring, firing, or paying employees on grounds of race, color, religion, national origin, or sex. Federal funds barred discrimination in any activity receiving federal assistance. Voter registration, 1965. Authorized appointment by the Civil Service Commission of voting examiners who would require registration of all eligible voters in federal, state, and local elections. General or primary in areas where discrimination was found to be practiced or where less than 50% of voting age residents were registered to vote in 1964 election. The law was to have expired in 1970, but Congress extended it, and I don't believe it expired in 2007. Literacy tests, suspended use of literacy tests or other devices to prevent African Americans from voting. 1968, the Housing Act, banned by stages discrimination in sale or rental of most housing, but it excluded private owners who sold or rent their homes without the services of a real estate broker. Riots made it a federal crime to use interstate commerce to organize or incite a riot. 1972, education prohibited sex discrimination in education programs receiving federal aid. 1988, discrimination. If any part of an organization receives federal aid, no part of the organization may discriminate on the basis of race, sex, age, or physical handicap. And discrimination made it easier to sue. In 1991, it made it easier to sue over job discrimination and collect damages. It overturned certain Supreme Court decisions, made it illegal for the government to adjust or norm test scores by race.